You're watching IPBC 2014 coming to you from Shanghai. China frequently comes in for criticism for its intellectual property enforcement. Frequently, companies overseas are worried that their patents, their intellectual property is not going to be respected when they do business in China. But we're here to find out what the situation is really like on the ground. And who better to ask than the man who started it all, the founder of China's modern intellectual property protection system. He was commissioner of the Chinese Patent Office in 1987 and went on to lead the then new Chinese Intellectual Property Rights Office for 2 years starting 1998. He is Dr. Gao Lulin, and these days chairman of Beijing East IP. Thank you so much for making yourself available today. So firstly, tell us, what is the greatest misconception that you tend to hear people say about China's IP system?
First of all, let me thank you for inviting me to have interview with your station. China, as you know, established its IP system since 1985. It was the first trademark law in 1983. After that, approximately 30 years, we are strive to improve our IP system systematically, constantly. So now still, I think IP community worldwide still have some complaint. I would say first question is, the law is quite good. What about enforcement in China? Let me say enforcement issue in China also improving. In many cases, our judge have done the work very well, and they also handled many cases worldwide famous one. I give you one example. The success rate of the IP cases. If one side is foreign party, compare with both party are domestic one, then success rate for the foreign related, approximately 60%. For the domestic one, only a little bit higher than 10% difference. But I recognize we still have some question about enforcement. For example, statutory damage is relatively low. Despite of that, in recent years, we revised our copyright law, trademark law. Last revision of trademark law already increased statutory damage 3 times. So now can go the 3 million Chinese yuan for statutory damage. So my first question is that we have many progress in the area of enforcement. We still have some questions to be settled. Secondly, recently we have established IP court in Beijing, in Guangzhou, in Shanghai. Beijing already done. But I have some comments on this question. In my opinion, we should have IP court in the second instance or in the appeal level. For time being in China, only in the first instance. They combine all IP judge in one court called Beijing IP court.
Yes.
So you see, in this case, theoretically, countrywide, still will have 31 high court with second instance decision on IP. It still could be different, no consistency result of the IP court. This is also another enforcement question. The third one, I think the transparency. We always have many critics by foreign counterpart. They say, okay, we didn't know, we cannot predict what is the result of our case because in China, transparency of question is very obviously. So now start from the high Supreme Court, High Court, and Intermediate Court, which are responsible for IP cases, periodically issues a decision, IP. I would say for whole court decision, IP judge do the work best. So almost every cases you can find decision made by court. The question is that our foreign friends, they cannot read Chinese. So for this purpose, Beijing East IP colleagues, we do some analyze work and select some cases and make some discussion internally, and then we make the final analysis, and all this published and translated into English. We want to periodically to do this work, even with some famous institute, some famous university, law school, and International Society of China, to do this work systematically in order to increase transparency for our foreign friends. So this is the first question I would like to answer about enforcement.
What about issues like the very celebrated cases of goods from the West being copied wholesale in China? Land Rover being a recent example where a company called Land Wind, a local Chinese company, seemingly just copied the entire vehicle. It's very hard for the layman to tell those vehicles apart.
Yeah, I would tell you Toyota case. Toyota has a design patent, and another Chinese automobile factory copied, and they issued their new one. And then they say this Toyota design is a copy of the old model, so it is not valid as a design patent in China. In reality, this Chinese factory copied the design of Toyota. And through the long process of lawsuit, finally Toyota won their first case in China. This case was handled by Beijing East IP. So Toyota people are very happy. So this is the first case. Of course, I don't think so every case would be handled correctly. Maybe something or foreign friends are not satisfied. But according to our law system, you can appeal to the second instance. Even you are not satisfied with the second case decision, you still can go to the Supreme Court for so-called retrial case. In our case, we handled retrial case for trademark, and all this case prolonged 12 years, and finally we won this case. So, in other words, we have whole chain of lawsuit. If you lost your case as the first instance, you can go further.
Yes. Still, I suppose the fact that some Chinese companies just copy, as in your Toyota example, just copy the product, seems to suggest that there isn't a culture of respect for IP. To what extent have you seen that improve in the 20, 30 years that you've been associated with that?
Yes. We have IP concept only 30 years ago, and IP conscious or awareness not so high for everywhere. So we still have many education work to do for our people. I would say in Beijing, Shanghai, Guangzhou, more industrialized cities, people are very familiar with, but not all. Let me tell you, 10 years ago when I come back to Beijing, I call a taxi. I say I would go to the patent office. They say, what patent?
Right.
Yeah, we don't know what's patent. So now everybody in Beijing, I think at least they know the patent office, and the patents play more and more important role in their daily life, in their economic development. So I am optimistic. We will do our work even better and better. Of course, protection IP right in China will also deepen and deepen countrywide.
To what extent are the local Chinese companies as frustrated with enforcement in the past, or the seemingly slow development of the sector in the past, as the foreign companies looking to do business in China?
Yeah, some local company also express their dissatisfaction. You know, China is very huge country, and there are many individual or small entity. They don't know IP protection. So in China, we say many things just like you're hunting in the forest. You file first time and change to another place and file second time. So it's just like IP violation. So some individual, some small enterprise violate IP, violate your patent, then they shut down their shop and go to another point and file second time. So for us, this is a tough work to do, to educate our people. But I would tell you, government, from central government to government for every level, they attach great importance to strengthening IP protection. So
really, you really think?
Yeah, I think so. In China, for example, copyright violation. So some CD-ROM production line. So Guangdong province award, if you can tell me where is a copy line, I give you 1 million Chinese yuan. This is officially declared. So I don't know any other government in other countries, they do like this way.
Still, it's in fact the Chinese government itself which is sometimes accused of copyright or patent violations when, for example, you consider cases where foreign companies have had a great deal of pressure put on them. I'm thinking of GlaxoSmithKline, Microsoft, among others, where it seems that the state is more interested in taking over some of this IP to grow the local industry rather than to allow the foreigners to come in and make the profit.
It's, I think, not true. Let me give you a Microsoft example. As I know, Chinese government have some special agreement with Microsoft, and we promised all governmental institutions will use no pirated software or operation software used from the Microsoft. So my colleague from the ministry told me every year we have it's very easy to calculate how many PC we issued several years ago, for time being now mobile phone, and how many we pay, the rate of software we pay software, Microsoft. So Microsoft people very clear about that. So the total output of PC issued in China and how many software like a royalty or fee we should pay directly to the Microsoft. It's very, very easy for calculation. But still you can find some individuals in some corner of the city, they sell the pirated operation systems of Windows. Still we have, yeah.
When do you think that's going to?
We are very strictly to such kind of violation, infringement. In my opinion, we need to improve once violation. If you repeat several times, we need to make more heavy, even to criminal sanction against them. This is especially important during the internet, e-commerce activities. Sometimes some people repeatedly violate some trademark law or copyright law. But law didn't say very clearly, if you repeatedly do that, your guilty will be more heavy. Yeah.
Now, China has a reputation for being the factory of the world, producing goods which are largely designed outside of China. To what extent do you see that changing? That actually a lot of the research, development, innovation is taking place here?
Mm-hmm. I would say for China, we lack good designer. So despite of that, we have many design patents every year. In reality, the design, the product designed by Chinese designer, or I think not so many, especially for the luxurious goods. You see, Prada, Louis Vuitton, and many others. So very popular in China. So Chinese people, when they go abroad, and the first thing for them to buy this one, despite of that 10 times, 20 times price higher than domestic one. So in this case, you still can find some goods which is copied. Foreign design, for example, Louis Vuitton, as I know. But people still like no fake products. They want to have a real one. They bought it abroad, in Paris or elsewhere. Yes.
But do you find that the Chinese, they're certainly industrious, are they not also innovative? When you look at, for example, the number of patents in China compared to other places, let's say the United States, or the quality of the patents, how do they compare?
You are right. I would say quality of patent is a big issue for us. At the first stage, people pay more attention on the quantity. So when I was commissioner in Chinese Patent Office, the patent for invention, more than 60% come from abroad. Domestic one only 40 or less percent. So now completely changed the situation. Only 20 or 15% utility patent or patent for invention come from abroad. More than 80% in the 800,000 applications per year. Among them, 80% come from domestic one. So quantity is not a problem now for China, but quality, I think, is a big problem. So we need to encourage our people to do work in innovation and to make good invention. So otherwise, I give you some figure. If you look at the span life of patented product, for Chinese invention, very short, 3-4 years. If you have a foreign company, they apply patent in China, and the product life, patented product life, 10 years, 12 years. So it means that quality of the patent, foreign one, is much better and higher than China domestic one. So this is a direction for us to encourage our people to do the work, to do the invention work.
It's been very interesting speaking to you. Thank you so much for making the time. I hear the bell going here at IPBC 2014, so we'll let you get back to the conference. Thank you again for your time.
It's my pleasure to talk with you.
Thank you. Dr. Gao Lulin from Beijing East IP, former commissioner of China's Patent Office and Intellectual Property Office.